When I'm talking, you do not talk over me.
Bro, I got 10 in with 4 left to do. I do not care. It's 3 years.
You're making a huge mistake.
None of that, bro. None of the stuff you talking about right now make any sense to me. Do I care about it at all, even a little bit, man?
Mr. Jones, I don't care what you want with regard to that.
It's 3 extra years max. You work with the prosecution. You ain't here for me. It's 3 years, man. That's
I'm sorry?
3 years. That's nothing.
Are you able to read and write?
Sometimes. Depends on how many pictures are on.
All right, stop.
The hearing begins with immediate tension as Aaron Jones repeatedly interrupts the court and dismisses the seriousness of the situation. While the judge tries to explain the legal consequences he is facing, Jones insists that an additional 3 years in prison means very little to him. He repeatedly says, "It's only 3 years." Making it clear that he does not view the potential sentence as a significant threat, the judge quickly recognizes that the hearing could spiral out of control if firm boundaries are not established. Rather than engaging in a debate, he takes command of the courtroom and reminds Jones that court proceedings must follow rules and structure. Every time the judge attempts to explain an important legal issue, Jones cuts him off with comments suggesting that none of it matters. What becomes obvious almost immediately is that the court and the defendant are operating from completely different perspectives. The judge sees a felony case with serious consequences, while Jones views it as a simple matter that does not require extensive preparation or concern. This difference in mindset sets the stage for the confrontation that follows and foreshadows the difficult decisions that will soon be made.
Present before the court with counsel, Ms. Morton. Mr. Arnold's here on behalf of the state of Ohio. I've been told that there's an issue.
Your Honor, my client has indicated to me that he might want to represent himself in this matter. I just wanted to bring it to the court's attention to have the court address that issue.
All right, Mr. Jones, why don't you tell me what's going on?
I just want to represent myself. I feel like nobody's going to fight for me like I'm going to fight for myself. I've been through voir dire, I've been through jury trials. I've done all this before.
Did you go to law school?
No, I did not, sir.
So do you know all of the rules of evidence and the rules of criminal procedure?
I don't think I really need it with this case.
Yes, you do. You absolutely need them, because every time something happens, Mr. Arnold here has been a practicing trial attorney with the prosecutor's office in Hamilton County and Warren County for how long, Mr. Arnold?
Well, if you add in military time, almost 46 years.
46 years. He's a skilled trial attorney. He knows the rules of evidence and he knows the rules of procedure. You can roll your eyes at me all you want.
I don't really care about none of that.
But here's the problem.
The hearing takes a dramatic turn when Jones announces that he wants to fire his attorney and represent himself. He tells the court that nobody is going to fight harder for him than he will fight for himself. In his mind, relying on another lawyer is a mistake because he believes his own interests are best protected by his own actions. The judge immediately begins questioning him about that decision. He asks whether Jones has any formal legal education, whether he attended law school, and whether he understands the rules that govern criminal trials. Jones openly admits that he has never gone to law school and has no professional legal training. Despite that admission, he insists that he does not need it. Jones argues that he has participated in multiple trials before and has spent enough time around the legal system to understand what is happening. To him, experience as a defendant seems equivalent to experience as a lawyer. The judge strongly disagrees and begins explaining why that assumption is dangerous. Merely sitting through court proceedings does not mean someone understands how to properly conduct a trial. The court becomes increasingly concerned that Jones is making a decision based on frustration and emotion rather than a full understanding of the consequences. Nevertheless, Jones remains determined to proceed down a path that many legal experts consider extremely risky.
I'm required by my canons that I hold you to the same standard that I hold Mr. Arnold, even though you have no formal training or education in the law. I'm sorry?
It will be all right.
As the discussion continues, the judge attempts to show Jones the enormous gap between courtroom exposure and actual legal expertise. He points out that the prosecutor handling the case has spent decades practicing law and conducting criminal trials. Every objection, motion, procedural rule, and evidentiary issue is something the prosecutor has dealt with for years. Jones responds with skepticism. He suggests that perhaps he could be just as capable if given the opportunity. He compares legal practice to other life experiences, arguing that people never know how talented they might be until they try something for themselves. While that argument might apply in many situations, the judge explains that criminal trials are different. The judge emphasizes that legal mistakes are not simply learning experiences. In a criminal trial, one mistake can affect evidence, witness testimony, jury perception, or appeal rights. Unlike many other activities, there is no opportunity to restart the process once errors occur. Despite these warnings, Jones continues believing that confidence and determination can compensate for his lack of training. The judge sees a defendant preparing to enter a highly technical legal battle without the tools necessary to compete effectively against experienced prosecutors.
All right.
It won't be all right. I'm telling you,
That's
you
3
won't.
years, man. It ain't no time, bro. I got 10 in, 4 left to do. I do not care at all, even a little bit. It's 3 years. It's cut and dry. What happened, happened. I didn't start this. Let the jury decide. I don't care about none of that, bro. None of the stuff you talking about right now make any sense to me. Do I care about it at all, even a little bit, man? It's 3 extra years max.
So what are you telling me?
I'm telling you, I can represent myself. I can handle it. It's not that serious.
Ms. Martin is a skilled trial attorney.
That's cool. I might be a skilled trial attorney too. Sometimes you gotta try stuff in life and you never know how good you might be at that.
You ever picked a jury before?
I have. I've been through mass of those. I've been through at least 7 different ones of those. Some of them didn't go all the way through. People got sick and stuff like that. Had to do it all over again.
You realize that if you do this, you cannot use ineffective assistance of counsel as a grounds for an appeal. It's not a basis for an appeal. You'll be representing yourself. You'll be held to the exact same standards that I hold Mr. Arnold to, and it would be a huge mistake.
All right.
I'm
That's
sorry?
Cool.
It's not cool. It's you're making a huge mistake.
I mean, I made a whole bunch of them. I'm sitting in prison right now for something I didn't do, so I make a lot of mistakes. You can't live life with regret, man. You gotta do what you gotta do.
Well, I'm inclined to decline that request. We are here on the day of jury trial. The jury is waiting for me to bring them down. I'm inclined to allow Ms. Martin to proceed representing you.
I don't want Ms. Martin representing me. I want to represent myself. I don't need somebody that's going to lay down and work with the prosecution. I'm going to do what
Ms.
I
Martin
gotta do.
does not.
I mean, that's cool. Your opinion is irrelevant in this matter. Your opinion is not helping her none. You work with the prosecution. You ain't here for me.
You are incorrect. I do not work with the prosecution. I do not work with the defense counsel. Actually, one of my functions here is to make sure that your constitutional rights are protected, which is what I'm doing right now. I'm sorry?
That will be tested. We will see about that.
The other problem is obviously you have a right to remain silent with you asking questions, and you're making a huge mistake.
It's added to the list. It's a whole bunch of them. It's a long list.
Has anyone threatened you in any way or promised you anything in order to get you to waive your right to counsel?
No. Just want to represent myself. I can't go any worse than it might be about to go. It's only 3 years, man. It's only 3 years. I got that.
And as long as you understand that in asking questions, in picking the jury, in everything that you do, here's the other problem. Here's the other problem. Is he in shackles?
Yes.
Okay, there's the other problem. Because you are in custody, you have shackles on. You want the jury to see you in shackles?
That's grounds for an appeal by itself. I realize that part. They're not supposed to let the jury see me in shackles, so I mean that's kind of like a tipsy-turvy type of thing right there. Know a little bit more than most. Ain't all the way simple, close to it, but a little bit more.
One of the most striking aspects of the hearing is Jones' repeated claim that he has nothing to lose. Over and over, he tells the court that 3 years is not a big deal. He appears convinced that the potential consequences are minor compared to the sentence he is already serving. The judge tries to explain why that reasoning is flawed. Additional prison time can dramatically affect a person's future, particularly when sentences are structured in specific ways. Whether a sentence runs consecutively or concurrently can make a significant difference in how much time someone actually serves. Jones remains largely unmoved. From his perspective, he is already in prison and facing difficult circumstances. That reality seems to make him less concerned about future consequences than the court believes he should be. His comments suggest a level of detachment that worries the judge. What the court hears is not confidence but resignation. The judge recognizes that defendants who believe they have nothing to lose often make impulsive decisions because they underestimate the risks involved. That mindset can lead them to reject legal advice, ignore strategic considerations, and take unnecessary chances that ultimately worsen their situation.
You've been handed a waiver of right to counsel. You understand that you have the absolute constitutional right to be represented by an attorney. Do you understand that?
Yes, sir.
You understand that you are not being charged for Ms. Martin's services, that you have the right to have an attorney appointed to you free of charge. You understand that?
Yes, sir.
And you understand the charge against you is a felony of the third degree assault because of your status, the status of the alleged victim, and the location of the incident being in the Department of Corrections, that the maximum penalty is 36 months in prison.
Correct.
All right. Are you aware of any possible defenses to this charge or this allegation?
Meaning what?
I'm just asking the question.
I
Are you aware of any? Are you aware of any?
I don't understand the question you're asking, sir.
Well, you're going to represent yourself and put on a defense, I assume, at least by way of cross-examining the witnesses presented by the state.
Right.
You understand that?
Yes, sir.
All right. You understand that there may be possible defenses that you could raise in your cross-examination of the state's witnesses or in presentation of witnesses on your own behalf. You understand that?
Like impeaching a witness?
Sir, I'm not going to explain every single thing to you. That's why I'm trying to encourage you to go with counsel here. Do you understand?
Yes, sir.
All right. There may be possible mitigating circumstances. Do you understand that?
Huh? No, I don't.
You don't know what mitigating circumstances are? Again, that's another reason why you need to have
3 years, man. That's
I'm sorry?
3 years. That's nothing.
Let me tell you something. If when I'm talking, you do not talk over me. Do you understand that?
Yes, sir.
You're not going to misbehave in my courtroom. You're not going to misbehave in front of this jury, because I'm going to tell you right now, it's going to end very quickly and very badly for you if you do.
Knowing the seriousness of the situation, the judge carefully begins a formal discussion about the risks of self-representation. He explains that every criminal defendant has a constitutional right to counsel, but that right can be waived if the defendant knowingly and voluntarily chooses to proceed alone. The judge repeatedly warns Jones that representing himself is almost certainly going to hurt his case. He explains that professional attorneys spend years studying evidence rules, criminal procedure, courtroom strategy, and trial advocacy. Those skills cannot be learned during a trial. Another major warning involves appeals. The judge explains that if Jones acts as his own attorney, he cannot later claim that his lawyer performed poorly. Any mistakes made during trial will belong to him. That means strategic errors, procedural mistakes, and missed opportunities could permanently affect the outcome of the case. Even after hearing all of this, Jones remains stubbornly confident. While he acknowledges the judge's warnings, he repeatedly suggests that everyone is entitled to an opinion. In his mind, the judge's concerns are simply one viewpoint rather than a serious caution based on years of legal experience.
3 years.
Well, you're the one that's elected to go with the jury trial, so you keep on saying it's only 3 years. That's fine. All right.
They try to give me 2 of it anyways. Might as well go to trial.
Okay. You understand, and I've told you several times now, if you represent, you will be detrimental. It will be detrimental to your case. You understand that?
I don't know if I believe that. That's your opinion.
It is my opinion, and I'm strongly advising you against it. But do you understand that in my opinion, if you represent yourself, it will be detrimental to your case?
Everybody's entitled to their opinion.
Okay. But you understand what I'm telling you?
Yes, sir.
All right. And you understand that if you represent yourself, you're going to be held to the same standards as any other defense attorney and the same standards as I'm going to hold Mr. Arnold. You understand that?
Yes, sir.
Have you ever represented yourself before in any criminal prosecution?
No, sir.
And you wish to go forward today without the assistance of an attorney?
Can I get a few minutes? I use the bathroom anyways.
Few minutes for what?
To use the bathroom, think about it, make sure this is what I want to do.
As the hearing moves forward, tensions between Jones and the court continue to increase. Jones openly accuses his attorney of working with the prosecution instead of fighting for him. He claims he does not trust her and believes she is more interested in reaching agreements than defending his interests. The accusation immediately draws a response from the judge. He explains that defense attorneys do not work for prosecutors and that the legal system depends on each side fulfilling its proper role. The court's responsibility is to ensure fairness, not to assist one side against the other. Jones remains unconvinced. He repeatedly questions the motives of the people around him and suggests that nobody is truly acting in his best interests. His distrust becomes a major factor in his desire to represent himself. The exchange grows increasingly heated as both sides become frustrated. The judge continues trying to explain legal realities, while Jones continues viewing those explanations through the lens of suspicion and frustration. What begins as a discussion about legal representation slowly transforms into a clash over trust, authority, and control.
Your Honor, I didn't get that opportunity to use the bathroom. Your officer wouldn't allow me to come out the cuffs. I don't know how I'm supposed to. I don't want to be rude or crude. Like, I know I got off to a bad start with you, sir, and that's not what my intentions were. I'm just kind of obnoxious. I'm sorry.
Yeah, I'm not in charge of security here, Mr. Jones. The
So
deputies and the transport officers are in charge of your
So
security of this.
how I'm supposed to use the bathroom in
Sir?
cuffs? How I'm supposed to be able to wipe myself in cuffs?
All right.
The officer refused to move the cuffs when I was locked in the cell. I'm just trying to use the bathroom. I need to use the bathroom before we get started, sir.
Rhodes,
Yes, sir.
what's the issue with him?
I was never asked to remove the cuffs.
She was, man. You know I had to use the bathroom. I don't know what else I'm supposed to say. I need the cuffs.
All right, let's get through this and we'll talk about your bathroom after that. All right. I advise you that you're charged with an assault of a corrections officer as an inmate at the correctional facility. Maximum penalty, as we've said, is 36 months in prison. Now, the issues that present themselves with regard to you representing yourself, obviously, is a logistics issue since you are incarcerated.
Eventually, the judge reaches a point where strong intervention becomes necessary. Jones repeatedly interrupts the proceedings, talks over the court, and refuses to let questions be completed before responding. The judge decides to make the rules absolutely clear that I in a firm tone. He tells Jones that when the court is speaking, he is not to interrupt. The warning is direct and unmistakable. The judge explains that such behavior will not be tolerated during trial, particularly in front of a jury. The concern extends beyond courtroom etiquette. Jurors pay close attention to how defendants conduct themselves. Repeated interruptions, disrespectful behavior, or refusal to follow instructions can affect how jurors perceive credibility and character. The judge warns that if Jones behaves in front of the jury the way he is behaving during the hearing, the consequences could be severe. Courtrooms operate under strict authority, and judges have broad powers to maintain order. The exchange serves as a reminder that criminal trials are not debates between equals but structured legal proceedings governed by rules.
Shackles on your legs will remain. The court is going to make a finding, and again, if you want to have a hearing on this, Mr. Arnold.
Your Honor, I just asked the court to take note that he's previously been convicted of assault on a corrections officer and is an inmate incarcerated for offenses of violence.
So I'm going to make a finding that you pose a security risk to this courtroom. So the shackles on your legs are going to remain there. Now I'm going to accommodate you in that both the state and you will do your opening, your voir dire, your opening, the questioning of witnesses, and your closing arguments from counsel table. Now you can stand up at that table without your legs being seen because for the record, there's a skirt or the bench itself in front of you hides your feet. No one can see your legs. You understand that?
Yes, sir.
All right. So I've already told you that in the court's opinion, representing yourself is probably going to hurt your case, right? You understand that I've said to you already that the state of Ohio is represented by a competent, experienced trial attorney, and that you will be held to the same standard as Mr. Arnold. You understand that?
Yes, sir.
All right. The rules of evidence and rules of procedure, even if you don't know them, will apply to you. Do you understand that?
Yes, sir.
I cannot assist you at all during the course of the trial.
Yes, sir.
You want to again understand that this is not a license for you to abuse the dignity of this court.
Yes, sir.
There will be no appeal for ineffective assistance of counsel.
Okay. Yes, sir.
Again, how old are you?
38.
How far did you go in school?
Dropped out.
So are you able to read and write?
Yes, sir.
Do you have any prior experience in representing yourself?
Not representing myself. I've always had good dialogue with my attorneys.
Okay. Do you have any prior experience, your prior experience in the legal system?
Just being charged with stuff.
Okay. You don't have any formal training in the law?
No, sir.
All right. And you have no mental deficiency or conditions that would interfere with you understanding what's going on here today?
Not that I'm aware of. Debatable,
All right.
though.
Now tell me once again, is it your intentions, is it your desire that you want to proceed in this trial representing yourself?
I'm pretty sure.
No, you got to be certain.
I mean,
Why don't we do this? Why don't we do this, Mr. Jones? Let's allow Ms. Martin to represent you, and if something happens and you can change your mind later. It's easier to go that way than to go the other way. You can't have it both ways. What's that?
I use the bathroom, please. I really gotta go, sir. I just need to use the bathroom. I'd be a lot more focused and stuff. I really gotta use the
All right,
bathroom.
Rhodes, take him to the bathroom. I'm not going to go over this with you again.
That's
You have this
fine.
one last opportunity.
I understand, sir.
All right.
After hours of arguing, Jones suddenly asks for a break so he can use the bathroom and think about his decision. What seems like a simple request ultimately becomes one of the most important moments of the hearing. When he returns, his demeanor is noticeably different. The aggressive attitude that dominated earlier exchanges has softened considerably. He apologizes to the judge and admits that he may have come across as rude or obnoxious. For the first time, Jones appears willing to listen rather than argue. The courtroom atmosphere changes as the judge continues discussing the realities of self-representation. The conversation becomes calmer and more productive than before. The shift demonstrates how emotional stress can influence decision-making. Earlier, Jones seemed determined to reject every warning the court offered. After having time to reflect, he begins showing signs of uncertainty. The confidence that once appeared unshakable now seems less certain as the reality of trial approaches.
All right, we are back on the record in the state of Ohio versus Aaron Jones. Mr. Jones, you've had your second trip to the bathroom now. I take it everything went better?
Yes, sir.
All right, now, you have in front of you a form called waiver of counsel. I've gone over with you all of the elements of granting that waiver. Do you still wish to proceed as your own counsel?
I need to get some I need real counsel. I talked to my family. They was talking about hiring a lawyer. I thought it was a little more cut and dry. I had a little more confidence in Ms. Martin in that. And just at this point in time, I'd rather just wait on my family to get a lawyer for me.
But that's not going to happen. This case is proceeding to trial today.
I'll represent myself then.
You want Ms. Martin
No,
to...
I don't want her near me, around me, or nothing. She can.
All right, sign the form in front of you. All right, Ms. Martin, you'll stay behind Mr. Jones as standby counsel. Mr. Jones, that's your signature, sir?
Yes, sir.
And you read this document?
No, not really. Why is Miss Martin here?
Because I'm making her a standby counsel in case there's an issue. She'll be in the back of the courtroom.
I don't need no
Mr.
help.
Jones, I don't care what you want with regard to that. I'm following procedure, and this is what we're going to do. Read the form.
Following additional discussions and conversations with family members, Jones begins reconsidering his position. He tells the court that his relatives have discussed hiring a private attorney and that he would prefer to have experienced legal representation. This marks a dramatic reversal from his earlier statements. Just hours before, he insisted that nobody could represent him better than he could represent himself. Now he is openly acknowledging the value of professional counsel. Unfortunately, the timing creates a problem. The jury is already waiting. Witnesses are prepared, and the court has scheduled the case for trial. Delaying proceedings at the last minute would disrupt the entire process. When the judge informs him that the trial will move forward as scheduled, Jones finds himself facing a difficult choice. He can continue with appointed counsel or proceed on his own. Rather than accepting representation from the attorney he distrusts, he once again chooses self-representation. The sudden reversal highlights how uncertainty, frustration, and pressure can cause defendants to change positions multiple times within a single hearing.
Form, please.
Mr.
Jones, read.
Of representing myself was because I didn't trust the lady. That was the
Okay,
whole purpose of
she's
that.
not,
But
she's
she's still here and attached to my case. That's the
She's
whole
removing
purpose of
herself.
removing her was for me to be able to represent myself.
You will be. Sign the form. Read
It was
it.
already signed. You
All
already
right,
seen my
read.
signature. You already
I'm sorry, I
asked me my
misspoke.
signature. You see my signature was on that sheet. You already said it was there. What are you talking about?
Mr. Jones, read the form. You said you
I already
didn't read
signed
it.
it, man. It's cool. Go ahead.
Read the form. Are you able to read and write?
Sometimes. Depends on how many pictures are on.
You done?
I ain't read it. I
the
already
form.
signed it. We already went over it. It's cool.
All right, the court will make a finding then, sir, that you've made a knowing, intelligent, and voluntary waiver of your right to counsel, and the court will accept that. Ms. Martin will stay in the courtroom as standby counsel. Other than that, are we ready to...
Ms. Martin is standing by counsel.
Mr. Jones, I'm going to tell you one...
Counsel.
Mr. Jones, I'm going to tell you
I'm not allowed to object. I'm my own counsel now. I'm allowed to object, ain't I?
Then you say the word objection.
I did. I said I object.
What are you objecting to?
I'm objecting to Ms. Martin stand by as counsel. I'm representing myself. I'm objecting to having her here. I don't trust her. So that's the whole reason of me releasing her, was to represent myself, because I didn't feel confident with her abilities, nor did I feel confident enough with her not working with the prosecution in order to help lay down and obtain a conviction. My removing of her wasn't based on...
Stop. Your objection is overruled. Ms. Martin will stay in the courtroom as acting counsel. Standby counsel, sorry. All right, are we ready to bring the jury down?
Yes, Your Honor.
In the final stage of the hearing, the judge presents Jones with a formal waiver of counsel. The document confirms that he understands the risks and is voluntarily choosing to represent himself. Even at this point, however, conflict continues. Jones objects to the presence of standby counsel, arguing that keeping his former attorney involved defeats the purpose of self-representation. He insists that he does not trust her and wants her completely removed from the case. The judge rejects the objection. He explains that standby counsel will remain available in case legal issues arise during trial. While Jones may represent himself, the court believes having an experienced attorney nearby is necessary to ensure the proceedings run smoothly. After one final series of warnings, the judge accepts the waiver. The jury is brought into the courtroom, and Jones officially becomes his own attorney. The moment represents a major turning point. What began as frustration with appointed counsel has evolved into a high-stakes legal gamble. Despite repeated warnings from the judge, despite admitting he lacks legal training, and despite briefly reconsidering his choice, Jones ultimately decides to stand alone against an experienced prosecution team that as the trial begins, one question hangs over the courtroom. Will confidence be enough, or has Jones just made the biggest mistake of his case?